Okay, I'd like to welcome you all to another video presentation. My name is Calvin Wright. I'm a realtor out of Dallas, Texas, and today we are going to review the residential buyer / tenant representation agreement. Now, if you have ever decided to buy a property, typically you will call around, try to contact the realtor, and basically you will tell the realtor your specifications on what you want to buy. Now, after you tell the realtor your specifications, typically a realtor will somehow show you this representation buyer's agreement form. Sometimes it might be at the very beginning when you start your search for properties. Other times the realtor might wait and show you a couple of properties to show you the residential agreement. And then other times the agent might wait until you're ready to make an offer. And then what the agent will do is send over the offer paperwork along with the residential representation agreement. Now, basically what this agreement means, it means that you are deciding to utilize the particular realtor's services. So what you're doing is you are making that particular realtor your exclusive realtor to basically find you deals, find you properties in reference to what you're trying to find and buy. Representation agreements are negotiable in reference to how long they last. So it could last 30 days, it could last 30 days, it can last 3 months, it could last 6 months. It all depends on what you and the realtor decide. Now, when you are viewing the residential representation agreement, you're going to see number one where it shows the parties to this agreement. The parties to the agreement is going to be your name at the top, your address, your city, state, and zip where you stay, phone number, and email, and if you have a fax. Also, if your agent, when your agent fills it in, the agent is going to put the broker's information here along with their name, the address, city, state, and zip, phone number, fax number, and email. When you look at number 2, you're basically giving the agent the right to be exclusive with you. So that's what a buyer's representation agreement is. It makes you exclusive with the agent to go and find you properties or go and find you properties to rent. When we talk about definitions, it gives you the definition of acquire, closing, and market area. Typically, when we talk about acquire, it means to purchase or lease a property. Closing is typically when you're going to go to closing. It kind of gives you an idea of what it is. The definition of meaning, it's a binding a date under contract to buy, and then it also means on a lease when you are getting ready to lease a property. When we look at market area, typically the agent will put either the county or put the city in this particular area. It also talks about the definition of property in this section here, meaning any interest in real estate, including but not limited to the properties that are listed in the MLS. Now, one of the key things to pay attention to on the buyer's rep agreement is the terms. Now, in this particular section here, this is where the agent is going to put the start date of the agreement, and the agent is going to put the end date of the agreement. Now, a lot of times when you're wondering how long you are in this particular contract with the agent, it's going to spell it out right here. It's going to say the agreement when it starts, and it also tells you when it ends. So that lets you know that whenever the end date is, whenever your end date is, what that means is you will basically be out of agreement with the agent that you're working with. Now, there are a lot of things that are located in an agreement that will extend the time, possibly maybe another 30 days of the agreement, or the agent might come back and ask you to basically do an extension on the agreement. And when they do an extension on the agreement, it only means that they're extending the agreement until you basically find a property that you're interested in, or until the property closes. What this talks about, it talks about your obligation as a client. You basically are saying that you're going to exclusively work with the current agent that you are with. A lot of times what we tend to have happen in the industry is when you're searching for properties, sometimes you may have a tendency to want to call the listing agent and have the listing agent to show you the house. What you need to understand is, because you have a exclusive right with the current agent you're working with, the current agent that you're working with's job is to show you properties. So what you would need to do, instead of calling the listing agent to show you that particular property, you would need to go back to the agent that you have the agreement with, and you would have to let the agent know that you have properties that you want to see. That's what we have to remember when you are dealing with these agreements. Under representation C, you're basically saying that the information that you are giving the realtor is true and correct. Number D is in reference to if the agent found you through a relocation company. If so, the agent would put in the area that you are interested in moving to. This will either be a county or it would be a city. One of the things to pay attention to is intermediary status. When we talk about intermediary status, basically what we're saying is, if for some reason, for example, if I had a listing that was located in Richardson, and let's say you didn't have a realtor just yet, but you decided to go with a realtor who is with the same brokerage as I am. If you choose a realtor who is with the same broker as me, what this would do is this would put us in a intermediary status. So we are basically under one broker. Now, when these buyer's representations forms are filled out, an agent will typically check off A, and the reason is because if the agent has a lot of listings with the particular broker that they work with, a lot of times if you are shown those particular properties, and let's say for instance you saw the third property and you are very interested in placing an offer on the property, then this will put that particular property in a intermediary status. Now, if you do not want to be put in a intermediary status, then B would be checked. And so what that is stating, or what you're saying, is that if the broker or if the realtor or broker shows you properties that are their listings, then you're saying that you don't want to be in an intermediary status. So the agent would have to show you other brokers' properties or other agents' properties that is with a different broker and not the current broker. Okay, so intermediary status basically means that you are housed under one broker. No intermediary status is saying that you don't want to see that particular broker's properties. Okay. Now, note that when a broker is acting under a mediary status, typically there will be a form, which is an IBAS form, that they will show you, and they will have you to initial the form at the time that you are making an offer. And the reason why this form is initial is because you're stating that you do understand that you are entering in a intermediary status, whereas you are basically basically there is only one brokerage firm that is in that particular transaction. Number 9 is talking about competence climb, that you are saying and you're acknowledging that the broker may represent other prospective buyers or other tenants who may seek to acquire properties, and that they may be interested to the client. So the client agrees that the broker may, during the terms of this agreement and at the end, represent such other prospects. So you're saying that you're okay with that particular agent having other clients or prospects that they represent. Number 10, it talks about confidential information. Typically, when you're working with a realtor, it's the realtor's job to basically keep all information confidential, unless, of course, in writing you decide that it's okay for the realtor to give certain information to the other agent, or in a transaction there is certain information that an agent might share. And the confidentiality statement means that, if you agree that you don't want certain information to be shown, then the agent has to abide by what you're asking them to do. So that's what it's stating. It says in number B, unless otherwise agreed or required by law, a seller or seller's agent is not obligated to keep the existence of any offer or terms confidential. If a listing agent receives multiple offers, the listing agent is obligated to treat the competing buyers fairly. So it's letting you know that the listing agent is supposed to treat every offer fairly. However, keep in mind that an owner does not have to look at your offer. That's one of the things that gets confusing when you're making an offer in real estate, because you're feeling that the owner has to look at your offer, and typically the agent will send the offer over. The other agent will say, okay, they have received the offer, but it's typically up to the seller to decide if they basically want to counter that offer, if they basically want to accept the offer, or if they basically want to reject the offer, or if they basically want to ignore the offer. So that's where it all gets confusing, because you're thinking that maybe the seller is not looking at your offer, but in real estate the seller doesn't necessarily have to basically look at the offer. They can just put the offer to the side and look at other offers if they so choose to do that. But as a courtesy, and this is some courtesies of some listing agents like myself, will probably send you a courtesy email to let you know that the seller decided not to accept the offer, or the seller rejects the offer. So it's solely up to the seller to decide on whether they want to look at your offer, reject your offer, or accept your offer, or not look at the offer at all. If you look at number 11 is a very important section. Number 11 talks about the broker's fees. When we get down to the brokerage fees, a lot of times people get confused about this part. If you are in agreement with an agent, this is typically where the commission amount will be listed on what they will make. Now, a lot of times buyers get told, oh, well, don't worry about the commission, because a lot of times the seller will take care of the commission. That's not always so, because in this particular agreement, this is an agreement between you and the buyer's agent. So this is a binding agreement between you two. So if you put in this spot 3%, and you go see a property down the street, but in the MLS is only willing to pay the buyer's agent or the selling agent only 2.5%, then that is a 0.50% difference. Now, how that would happen is the agent has to get paid somehow. So the agent would have to come to you for the 0.5%. So keep this in mind when you're searching for properties, and if you sign a buyer's representation agreement. And for example, again, if this says 3% here, and you go see a house and you fell in love with that house, but they are only willing to pay 2.0% to your agent, then under this particular agreement states that you owe that agent 1%. And so typically the other 1% would have to come out of your pocket. Now that's what we want to make sure that you understand under buyer's fees. The second part of this is talking about rent fees in reference to leasing properties. Typically, whatever is in this little area here, it might say 50% of the first month rent or 50% of the first rent and deposit. So this is where all of this information is if you were to deal with an agent who's finding you a property to lease. The agent has to get paid, and typically you need to understand that it has to come from somewhere. If the seller is not willing to pay the percentage, then you are under the obligation of the buyer's representation agreement to pay that other percent. When it talks about source, it talks about buyer will seek the obligation payment or commission in paragraph 11A first from the seller. Now remember, it's right here. They're going to seek it first from the seller, landlord, or their agents. If such person refuses, now this is why this is particularly underlined. If such person refuses or fails to pay the broker the amount specified, client will pay. That's you. You are the client. Client will pay broker the amount specified less any amounts broker received from such person. That's exactly what we just talked about in reference to this particular broker fees. Now, you can typically read numbers C, D, and E. Talks about earn and person. A person is not obligated to pay broker or commission until such time as the broker commission is earned and paid. So you're not under obligation to pay the broker up front or anything like that. But we also talk about that sometimes there are like additional compensation if the seller, landlord, or the agent offer compensation in excess of the amount of paragraph 11A, including but not limited to marketing incentives or bonuses to brokers. Brokers may retain the additional compensation in addition to specific commissions. Now, I want you to know that a lot of times there are agents who will ask for a small upfront fee. Now, this ranges in the market. It doesn't necessarily mean that an agent is going to do that, but there are some agents who will charge a small fee before you go out to view properties. And a lot of times the agent is trying to make sure that you are a serious buyer. If you are not a serious buyer, a lot of times agents in the past have shown properties to buyers, and some of the buyers either didn't have a qualification letter or didn't qualify for the properties. So now in the industry, a lot of the agents are saying, okay, well, before I show you properties, I may have to charge a $200 fee up front. And typically some agents will rebate this fee at the end of closing. They will give the money back to you at the end of closing as a rebate, or some other agents may not have a rebate. Now again, this will depend on the agent that you're dealing with, because every agent is different. Always remember that in real estate. We are not all the same, and we don't have all the same fees. There is no set fees in real estate. Everything is negotiable in real estate. Number E talks about acquisition of broker's listing. Notwithstanding any provision, if a client acquires a property listed by the broker will be paid in accordance with the terms of the broker listing agreement. Okay, so these are other paragraphs in here that talks about it. Now, F is typically if for some reason you are referred like a service provider by the agent. Sometimes the agents will get paid fees off of that, and that's what this talks about, additional commissions and fees. And this is something that you would need to read. Now, again, G is what we call a protection period of the agreement. A lot of times, agent will probably put 30 days in this spot to say that if for some reason the agreement terminates, if the agreement terminates on this particular date, the protection period will extend this buyer's representation agreement. That's what it means. So if it gets extended 30 days, that means this agreement will extend out another 30 days. And it says no later than 10 days after this agreement end, buyer may send a client written notice identifying the properties called the client attention during this agreement. So this is what it is. Sometimes, let's say if you have a 4-month agreement and you put an offer in on the property and you don't close on time and the agreement is going to expire, typically a protection period would allow the extension of the agreement, and it would allow the extension for 30 days. Number 8, it talks about escrow authorization. Client authorize a broker. So instruct any escrow closing officer authorized to close a transaction for acquisition of property by this agreement to collect and distribute to the broker all amounts paid to the broker. So it lets you know that typically the escrow officer will basically pay the agents, and the agents are paid at closing. County talks about the particular county that the broker will be paid. This county can vary. It could be Dallas County, it could be Fort Worth, it could be Tarrant, which is Fort Worth, it could be Collins. So that statement right there will vary. 12 talks about mediation. If for some reason you get in a dispute with the seller, or if some reason you get in a dispute with your agent over the buyer's representation agreement, number 12 talks about that typically out of good faith there's a possibility that there will be a mediator who will come in to basically help to resolve the issue that you're having in reference to your agent. So if for some reason you disagree with paying the 1%, and the agent is letting you know that they've showed you properties, you owe 1% to them, and this is what we was talking about earlier. So you may owe 1%, and you may say, well, I'm not paying the 1% because you told me that the seller was going to pay, But all in all, this is what mediation is. It means that if for some reason you and the agent cannot come to terms on the particular amount of the agreement, then there will be a third-party mediation company that will come in to help to offset you two's fury with each other. Okay, number 13, it talks about the default. That's something that you want to make sure you understand under the agreement. It gives you the understanding of what is the default exercise and the remedies of the particular agreement. So basically, if you default on the agreement, then this paragraph will take effect if you default on the agreement with your agent. Okay, 14, it talks about the attorney fees, and then 15 talks about the limitations of liabilities, and it talks about the limitations of what the broker is not responsible for and is not liable for. Okay, and that's a paragraph that you want to talk about. Now, a lot of times under addendum, we talked about it. You will see the information about brokerage services that will be checked off. Typically, if for some reason that you are buying a house that's older than 1974, typically you will have a lead-based addendum to sign as well, and you will also receive pamphlets in reference to lead-based. Number 18, it talks about additional notices. Broker fees, insurance fees by the brokers are not fixed, and this is what we talked about before. It's not fixed, it's not controlled, it's not recommended or suggested or maintained by the Associated Realtor or any listing service. So it's letting you know that the broker's fees are not fixed fees. In accordance with the Fair Housing Law, the National Association Realtor Code of Ethics, broker's services must be provided without regards to race, color, religion, national origin, sex, disability, family status, sexual orientation, gender identity. Local or ordinations may provide for additional protection class. Okay, so that gives you that statement to let you know that there should be no discrimination in reference to trying to find a house. Broker's not a property inspector or survey engineer, so therefore, because a realtor or a broker is not that, you have to seek the professional help in reference to that. If a client purchased property, client should have an abstract covering the property examination that's letting you know that you should have a title policy done, or you should have an abstract done. You should have the title checked before you buy the property. Client may purchase and also let you know that you can purchase a residential contract agreement with any residential services that you choose to go through. Now, what residential service contract is, pretty much a home warranty is what it is. So that's what it's typically known as, is home warranties. And you can basically go anywhere you want to try to find a residential service contract or a home warranty company. Okay, when viewing a property, client may be recorded or otherwise monitored without client's knowledge or consent. Additional consult an attorney before recording photographs of properties without owner's knowledge or consent. So you basically must get the consent of the owner. If you choosing to video the property, you must get consent from the owner to video a owner's property. Okay. It also talks about, to reduce risk of wire fraud, clients should refrain from transmitting personal information such as bank account numbers or any financial information via unsecured email or other electronic communication. If client receives an electronic communication regarding wire instructions, and even if the communication appears to come from a legitimate source, what they're saying is you should verify. And this is one of the main things that does go on in real estate in reference to wire fraud. So what you want to do is you want to make sure that it's coming from the place where it's supposed to come. You do not want to send funds on an unknown account or to an unknown source. So always verify. Always make sure you're verifying where you're sending money if you choose to use wire. Another way you could probably do is a cashier's check. Normally cashier's checks, or typically you can cancel a cashier's check, but it's very hard when you're dealing with wires and doing wire transfers. So you need to make sure that it's actually coming from the title company. Now this all talks about right here. This is where the agent will have their name printed. This is where the agent will sign and print their name. They will print the broker's name, and you will have your name, and you will sign and date it. So that's pretty much the end of this video in reference to buyer's representation. If for some odd reason you may have any other questions about it, feel free to contact me or give me a call. Also remember, by no means am I giving you legal advice. If you are in need of legal assistance, please seek the help of a real estate attorney. Also remember, if you like this video, click the like button and don't forget to subscribe.